So, hello everyone. Welcome to the Nest Egg Builder Show. I'm your host today, Aaron Goins, and I'm very, very excited for our guest speaker, Mr. Marc Garlett. He is a real estate attorney and investor in California. How you doing, Marc?
Hey, Aaron, I'm well. Thank you for having me.
Man, thank you for coming, man. Thank you for coming, man. So, I'm just going to ask you this question right here. How did you get started with your? Just talk about your career and things like that. Well, how did you get started?
Yeah, well, actually, I definitely do some real estate law, and I am a real estate investor, so it's near and dear to my heart, and I do that with clients. But main focus of my practice is estate planning, and I got started in that. I was doing litigation at the time, and then I had my first child, and my wife and I went out to find an estate planner to put together a plan for my family. And I couldn't find anybody that really got it and was kind of where I wanted it to be. And so I knew enough just to really annoy them as a lawyer. And so I would ask questions about, what happens under this scenario? What's going to happen to my child if this happens? And, couldn't find anybody that had all the answers. And part of the problem is this industry is geared towards old people. And so I wasn't in that situation. I had a young family, a new baby, and I needed a plan that could adapt to that, and nobody could really help me. And then we had our second child a couple of years later, and my wife started getting on me saying, now we got 2 kids, we still don't have an estate plan. Come on, what are you doing? So I went out and kind of figured out how to do it myself and tailor it to us with our situation as it was, and make sure that it could develop and adapt and grow. We weren't investing in real estate yet at that time. So now we've adapted our plan to encompass our real estate. My kids are now 12 and 14. So the plan, it hasn't adapted yet, but it will soon. When they turn 18, things need to be changed. But that's really what got me into it. Is I couldn't find anybody that was going to take care of my family the way I wanted them taken care of. And so I developed it myself. And then I thought it shouldn't have been this hard. There's an opportunity here, and I bet you there's other parents, other families that would like estate planning that was adapted to them, and not just sort of that one size fits all traditional plan. Here you go. And so I changed my practice area from litigation to estate planning. And over the time, as I started investing in real estate, I added that in because I became somewhat of an expert on my own stuff and wanted to be able to take that out to clients and help them generate wealth, protect that wealth, and pass that wealth. And really, for me, what this is all about is the legacy that we're building during our lives, and that we're putting together and preserving to pass on to our kids.
Awesome. So let me ask you this. Why is estate planning so important?
Well, a lot of reasons. And again, I kind of look at it through the lens of legacy, right? So for me, a huge part of my life is about the experiences I'm building, the values I'm instilling in my children, the connections I'm making in my community, the imprint that I'm making with my life on my little blip in time that I get to be here. And so estate planning is a part of that, because legal planning is one of I really look at it as 4 pillars of legacy. There's legal planning, financial, asset, wealth, that is all kind of that one financial area. And then personal, my own personal growth as a human being, that's important. And then my interpersonal relationships, my connections to my family, my friends, my community, my world. And legal planning is a huge part of that. Legal issues come up during our life. Laws are how we have decided as a society to relate to each other. And so it's important to have a good plan in place. All of this involves planning, all 4 of those pillars. I think you get a lot farther when you plan and you're intentional about where you want to go. And the legal part of that is no different. And certainly when we die, estate planning really comes into effect, or when we're incapacitated. It's not always about when we die. It's if we need help being able to manage something. If we don't have a plan in place, then the state gets involved in our affairs. And I don't know about you, but the state generally doesn't handle things nearly as well as I handle them myself. And so I would rather keep them out and make sure that I have a plan in place so that I can handle things. Helps avoid courts, which avoids cost. avoids a time drain and an emotional suck for our loved ones if they have to go through that.
Great. So a couple more questions I got for you.
All right. Throw them at me.
Everybody talks about a will, and I tell people about using a trust. Can you tell people why it's important to have a trust more so than a will?
Yeah, and that's true in almost all the cases, particularly in California, and the probate laws, and that's really what we're kind of zeroed in on, that particular aspect of the law, are different in every state. Every state has their own, and California is one of the worst. And so you want to avoid probate in California. Most people in California are going to be subject to probate. That is based on the value of the assets that we have when we die. Certainly, if you own real estate, you're going to be subject to probate. And if you have accumulated anything much at all of value over your life, you're going to be subject to probate. So there's three ways you can deal with that. You can do nothing, and you can take the state's plan. They'll give you a plan, and that is the probate court process to transfer assets out of your name into somebody else's name if you haven't already taken care of that before you die. And then there's a will. That's sort of that mid-level. You can have a will. A will does a couple of things. A will allows you to name your executor. Without a will, the judge is going to appoint that person, and an executor is a person who deals with the court to manage your assets until they get transferred to who they're supposed to go to. And you can determine who your assets are going to go to. You can name your beneficiaries in a will. Without a will, the court determines, it's under statutory law, who your heirs at law are. And that's basically your next of kin who's going to inherit your assets. With a will, you can circumvent them. You can give it to whoever you want. You don't have to be beholden to the laws of intestacy. And that's what that's called when you don't have a will. But that's all a will does. A will does not avoid probate. You still have to go through the whole process. And in California, probate is expensive. I tell people you're going to lose somewhere between 5 to 10% of the total value of your estate. That's how those fees are often calculated. It's based on a percentage of the total number of assets going through the probate process. And that's generally, when it's all said and done, you're going to fall somewhere in that range. It takes a long time. In California, right now, the average probate is somewhere right around 2 years. During that time, your assets are locked up by the court. Probate is not there to protect our loved ones. It is there to protect our creditors, and the court guards those assets until everything's all said and done before they get distributed to our families. So it's a long time. It's an emotional drain. You're beholden to the court's timeline when you want to be grieving and the loss of a loved one, but yet you have to deal with this. And you lose a lot of control with probate. So the courts gain a lot of control. And then particularly going back to my situation and anybody else that has young kids, what happens is that they're too young to inherit before they're 18. So the court would lock up those assets, name a conservator, may not be who I want managing those assets until they turn 18. And then as soon as they turn 18, on their 18th birthday, I have 2 kids, so they would each get half of what I've built. Half of my little real estate portfolio would go to each of those kids at 18. And under that scenario, they would have just lost their parents recently. So that is a recipe for disaster. And I don't want that to my kids. I want more control over how I give it to them, when I give it to them. And with probate, you lose all of that. So that is why a lot of people will establish a living trust or a revocable trust or a revocable living trust. So it's all the same thing, all different ways to talk about the same thing. But that is a trust. It is an instrument. It's actually based in contract law. So you're kind of making a contract between yourself and a trustee. The trustee is who will manage those assets for the benefit of the beneficiary. Now, during our lifetime, we're all three. So I'm making the trust as the trustor. I'm the trustee. I'm managing those assets during my lifetime, and they're for my benefit during my lifetime. When I die, I have a successor trustee that's going to step in and manage those for my beneficiaries at that time, which will be my children. And so if I put it in a living trust, any of my assets that I put in a living trust, and that's important. Do not just go out and buy some documents that say you've got a living trust and walk home and think you're protected, because you're not. You actually then have to take all of your assets and transfer title to them into the living trust. If you don't do that, you're still subject to probate. So whatever money and time you've spent on that trust has been wasted. But once you put those assets in that living trust, they're no longer in your name. So when you die, they are not subject to probate. Only assets that are in our name when we die are subject to probate. Anything that's in that trust can pass outside of probate. So it doesn't have to go to court. Courts never have to get involved with that. I get to choose who's going to manage that. It can happen in a matter of months that those assets can be transferred rather than years. And even during those months, my beneficiaries have full access to those assets during that transfer period. And I get to control how and when my kids get those assets so that I can make sure that they're mature enough to do that. And then some really neat things you can do with a trust. I can also designate what they can and can't do with those assets because I'm setting it up, right? Another thing that I can do is I can write my trust in such a way that my kids are protected. Whatever I give them is protected from any future divorces, lawsuits, bankruptcies, creditors. So instead of, I've got 2 kids. So statistically, it's likely that if they both get married, one of them will get divorced. But instead of that ex-spouse taking half of their stuff that I've given them, they get to keep that all to themselves. And that's what I want for them. So that's the way I've set up my trust. So you have a lot of control, and a trust is a very powerful way to not only help you build assets, but to protect those and pass those on to your kids. And if we teach them well, and it doesn't have to be your kids, it can be anybody that you want to give them to, but if whoever we give them to manages them well and grows those assets, it really is a powerful way to build and grow wealth from generation to generation without having it siphoned off through divorces and lawsuits and other sort of third parties, outsiders that want to come in and take our assets. That's why I love trusts.
Can I ask a question?
Well, hold on. We got questions at the end. Hold on, sir. I got a couple more questions before I open up. I promise. And I saw your face reaction too when he said that too. So I definitely understand. I saw you. So let me ask you this, Mark. I see it that a lot of people with trust, a lot of times with trust, you hear a lot of times how like the generational the money's gone by generation. And a lot of times, I look at the Rockefellers, for instance, and I see how they pass on money. They're still donating billions of dollars every year because of the trust that they had, that John D. Rockefeller did, and got passed on to generation. And that's one prime example that I always give people all the time. Can you explain a little bit more about that that process?
Yeah, so I think it's really interesting. Almost every culture has one of these sayings. The one I'm familiar with is I think it's shirt sleeves to shirt sleeves in 3 generations, right? So what that means is you got that first generation, sometimes an immigrant generation, but starting from nothing for whatever reason, or relatively modest means. Working their butts off, building something that they can be proud of and that they can have and that they give to their kids, right? Their kids either don't have an appreciation for that work because it's been given to them, or they have an appreciation, but they don't have to work as hard because they now have a means of assets to sort of sit back a little bit. And so they don't end up growing that. In fact, they end up squandering that in a lot of cases, or it's lost to divorces, lawsuits, or those kinds of things, or they don't make wise decisions, or you've got all these scammers out there, we all aware of that come take our money. So for whatever reason, that money gets depleted rather than growing for that third generation. And then the third generation is right back where the first generation was, building from nothing or building from very modest means again. And that cycle often repeats itself. And that is a problem if, like me, I want my legacy to positively impact people that I'll never meet, but that will come down my line, right? My great-great-grandchildren. I want them to be able to look back and say, wow, this guy way back there, did all this for us. And now we've got a good life because of that, but not set them up in a way that they're entitled and that they don't go out and do something and appreciate what they've got and build on it to pass on to their kids. And that's really, quite frankly, one of the big challenges in estate planning. If you do it well, then you've got that other side of the coin. How do we make sure that generation inheriting it respects it, takes care of it, builds on it, and then does the same thing for the generations that follow them? Did I answer your question, or did I get all off track and
No.
Okay.
It definitely answered my question. Definitely
Okay.
answered my question. So let's move on to real estate. Let's start with the basic stuff. I tell people all the time, especially who people get multifamily properties, to get an LLC, and then get an umbrella LLC in another state. Could you explain a little bit to people about that process?
Yeah. So if you're going to do things in an ideal world, and of course, in California, LLCs are expensive, so you have to look at that and make sure that it makes sense for you financially. But ideally, whatever you're going to have one LLC that owns each property. Okay, and then what you want to do is you want to have your trust be the owner of the LLC. So when we talk about transferring assets, right, you're not going to be the member of the LLC. Your trust is going to be the member of the LLC, so that asset can avoid probate and some of the other things that a trust can help you do, like we just talked about, making sure that you protect those assets in a certain way as they're passed down. And then what I do is we have a separate management LLC. So the LLCs that own the property, that's all they do. They own the property. We have a separate LLC then that manages the properties. So they all the money that comes into each of those LLCs from that individual property, they use that to hire the management company. We have one management company that manages the properties, and then you can do an umbrella LLC over all of the properties. Some people do it out of state. I personally don't really find a lot of benefit to that, unless there are certain states that will give you some benefits, but financial wise, you have to still pay that franchise tax fee from California, even as a foreign LLC doing business here. So there are some legal reasons to do that. Generally, that's going to be either a Delaware or a Wyoming LLC that give you the best legal benefits to do that. And that's great to do that. That's getting rather complex. So if you just have a couple of properties, you don't need that yet. But if you get up and you really start building a real estate portfolio that has something in it, that's definitely something to look at, because you want to protect those assets. And that is a great way to do it. One other comment that I'll give you, Aaron, on the LLCs is I have a lot of people that call me up and say, hey, I got an investment property. I need to put it in an LLC. And I say, okay, let me ask you some questions. First, do you own it outright, or do you have a mortgage on it? Well, I have a mortgage on it. Well, then you have to go check with that mortgage company to see if you can put that in an LLC. Otherwise, that is going to be considered by them as a transfer of title, and that will trigger the due on sale clause if they choose to exercise that. And that means your mortgage comes due and payable in 30 days because you've just transferred title without their permission. So you have to be careful about doing that. And I always suggest you get permission. Some lawyers out there will tell you it's easier to ask forgiveness than permission. I don't operate that way. It's because it's easy for me to play fast and loose with the client's money, but they're the ones who are going to have to pay for it if something goes wrong. So I don't want to ask for forgiveness instead of permission. I always encourage them to ask for permission first. Likely won't get it. I have several properties. I have mortgages on all my properties. I always ask, and I have yet to be approved to do that. I have had a couple of clients who've been approved to do that, but for the most part, it's not going to happen. So I would be very careful before you just transfer that if you have a mortgage on it, because that can get you into legal trouble. So what I do, and it's not as good as having them in an LLC, that's much better protection. And once, get to the point where I have everything paid off and own them free and clear, that's the direction I'll go. But for right now, we have a big fat umbrella insurance policy that goes over all of our individual property policies, our homeowners policies, that covers that, so that we've got a nice big cushion that a lawsuit would have to eat through before they could break out of that initial asset and get into the others. If that makes sense.
Yeah. I got you 1 minute, Peggy. Give me one more question. I'm gonna take it over to Peggy.
Okay.
So why have all this stuff? Why can't I just have this under my name? And, I just want to be cheap. So I want to keep everything under my name and things like that. what is the penalty for something like that if something happens to a property or somebody might slip, a tenant slip, trips and falls, something like that? What would be the penalty for something like that?
Yeah, and you're absolutely right, Aaron. You can do that, and you might be okay. Not everybody gets sued, and not everything turns bad. But part of what I do with planning is we want to plan for the worst, hope for the best. Because if you don't, and the worst happens, you can lose everything. Literally, you can lose everything, right? And we live in America. We all know it's a very litigious society. Litigation is incredibly expensive. When I used to do litigation, I'd have people come into my office angry and say, I want to sue so-and-so, right? And I'd say, okay, that's fine. That's how I make a living. So if you want to do that, I'll do that for you. But I recommend you calm down, you think about it, because here's what it's going to cost you. You may not think about it now. The emotion may be controlling you, but a year in, after you've paid me $75,000, $80,000, and we're still not even halfway done with your case, you're going to be really upset that you even started this, because it's hard to stop. Once you get that train running, the attorneys take over, the court is involved. You don't just say, oh, pull on the brakes and you're out of it. You lose a lot of control. So lawsuits cost a lot of money. And when you're talking about real estate, something as simple as a slip and fall can cost you big. But if there's a wrongful death, somebody dies on your property, a water heater explodes on them, or whatever happens, they're an idiot. They get drunk and get up on your roof and fall off and die. They're going to come after you. Their family's going to come after you, right? And so you can lose that piece of real estate. And part of what an LLC does is it compartmentalizes those. So if you have that in an LLC, and let me bounce back to the LLC, another important thing is you have to follow the procedures for an LLC. A lot of people will put it in an LLC, but not do all the paperwork and the required annual upkeep of that LLC. And then when they get into court, that's called piercing the corporate veil. The judge will look at that and say they did not follow through and do everything that they needed to on that LLC. So that LLC is nothing more than an alter ego of themselves. And so we are going to go after all of their personal assets. But if you keep that LLC up correctly, then the only thing vulnerable to that lawsuit are those assets contained within that particular LLC. So it's a shield around that asset. Anything in there is vulnerable, but anything outside of that has a shield around it.
Good stuff. Good stuff. Love it. Love it. Peggy, please ask your question.
Thanks, Mark, for this great presentation.
Hey, Peggy.
So I was just curious, as when you say put a person's personal home in their trust, it now gets recorded in the new name. What about the title insurance? I have yet to meet a trust attorney that tells me, for instance, you've got to contact your title company and tell them that you've just transferred that, because you can't have that break in title.
So there's two things on that, and you're absolutely right. And this is part of the problem in this industry. And when I was going out and asking these questions, there are very few attorneys that will, we call this funding, that will follow a client and take them through the funding process and make sure they get everything funded to the trust correctly. Because it's extra work, it's extra liability, and for the prices a lot of people charge for trust, it's not worth it to them to do it. And they would rather sell a trust that has all those holes in it than work with clients to make sure everything gets done right. But you're right, you're going to transfer title on the deed. You're going to record that deed with the county so that they know that that property is now held by the trust. If you have title insurance, now I always ask every client if they do. Most clients do not get their own title insurance policy. They just take the one that the mortgage company gets, and that's what I do too. I figure if it's good enough for them, I don't buy any additional, but you can buy an additional. And when they do and they have that policy, then we absolutely want to reach out to them and let them know that this property is now in the name of the trust. That's important. Or you're absolutely correct. That title insurance policy will be broken. And then the other thing is your homeowner's policy. I also want you to reach out to your agent for your homeowner's policy. And in that case, we don't change the policy to the trust. I still want that in your personal name, but we want to add the trust onto that policy as an additional named insured.
Thank you very much. That's great. I have a couple other questions, but I think Sarah had a question. I like to share time.
Sorry about my dog. You have answered so many questions, and I wish I knew you when my kids were little, because none of us had a will, and I don't know why we didn't. But you were talking about probate. So what if somebody has a minimum of assets and only cash reserves, say $600,000, and they pass away? It's even if they have a handwritten will that is notarized, it's still going to go through probate.
So the lawyer's answer is it depends, right? That's the good lawyer's answer for anything. But
never get away from you.
The threshold in California for probate is $167,250. Weird number. Used to be $150,000, and it was really easy. You just kind of did that, and then they just upped it a little bit this year. So if you're under that, we can do what we call a short form probate. So with that, you basically don't have to really get the courts involved. We have to do some legal documents, and it's basically an affidavit that we have the beneficiary sign, and then they can take that out. And if you have a will, even if it's a handwritten will, that's called a holographic will. And there are certain requirements to have a valid holographic will if it's just a handwritten will. But as long as it meets those requirements, they can take out a copy of that, the affidavit, and they can generally get a hold of those accounts that are under that threshold. So that's generally how that takes place there. In fact, I'm working on one now. And a lot of times they go pretty smooth. Got somebody at a bank who, I don't know if they're new, they don't understand this, they're giving us trouble. So I'm going to have to go file something with the court and get a court order to make them turn it over. But generally that will still be one time in court rather than the whole 2-year probate process. So as long as you're under that threshold and you talk to a lawyer that knows how to deal with that, they can generally get you prepared to go get that. Now, keep in mind that you don't have to do that for any joint accounts. If there's a joint account holder on that account, then that account's going to pass to them. You don't have to do it for any community property. And generally, life insurance and qualified retirement plans are exempt from probate anyway. Those will just pass to the beneficiary that are on the policy or that account.
Do you specifically work in California, or do you work in other states?
I do. I'm only licensed in California, so that is where I work, but I also have, I'm involved in a network of lawyers, and so I have some good contacts in other states. Depending on where you are, I might be able to hook you up with somebody that knows what they're doing, that treats their clients well, and that I've kind of vetted for you. So if you are in a different,
but I'm in Texas.
You're in Texas, okay. Well, if you are looking for a lawyer, you let me know. I'll reach out to my network. I don't. My close, I sort of have that inner circle of people that I communicate with a lot, and then the outer circle. I don't have anybody in Texas that's right in that inner circle that I could immediately off the top of my head refer you to, but I can certainly look in the outer circle. What part of Texas are you in? Oh, you're on mute now, Sarah, sorry.
I'm in Dallas, but I have your
Dallas,
information. So when I'm ready, I will email you.
Reach out to me and I'll try to help you as best I can.
Thank you.
I have one more question for you. And that is the LLC. We're talking about the LLC. So if someone has a property in another state, they're going to set up that LLC in another state. Correct?
Generally, yeah, I mean, generally that's probably the best way to do it because, if you again, you can do this as again, Delaware is a popular choice. Wyoming is a popular choice. You can do it out of state that sometimes give you some legal advantages because those particular states have very favorable in terms of if you're sued or some of those kinds of things. They have some very favorable legal advantages for you, but it also adds legal complexity to what you've got going on. So generally, I say if you're just starting out, you've got a relatively small portfolio. Usually, it's not worth it to add that level of complexity in. It ends up costing more, doesn't give you a lot of extra protection, and it makes things more complex, which makes things more expensive and more time consuming.
Once you get past that's not what I'm asking about. So there's people that buy properties all over the United States. Well, when you're in California, you put it into a California LLC, but if you've got it in Florida, you would put it in a Florida, because the property's in Florida, you would put it in a Florida LLC. What, you wouldn't put it in a California LLC if the property's.
No, that's what I'm trying to say. The only other LLCs you might want to put it in are one of those states that has those extra favorable laws. I definitely wouldn't put it in California LLC unless it's in California. But you do have options to go to maybe a Delaware LLC or a Wyoming LLC, wherever it is.
Why wouldn't you put it into an LLC in the state that the property is in?
Because those particular states, the way their laws are set up and the way that they have their LLCs set up, it sometimes gives you some legal advantages to have it in that particular LLC in the event of a lawsuit that you wouldn't get if you have it in your home state LLC.
Okay.
So it's kind of a legal game. You kind of look at what those advantages are versus what it's going to cost versus the complexity that it adds. And that's why I say most of the time, particularly with smaller portfolios, it's better just to put it in your home state and make it less complex and deal with it that way. When you get more complex, then it makes sense to at least look at that as an option, but it's not always the right option to do. I think you're right, Peggy. For most of the time, I'm going to suggest whatever state that property is in, that's where you put that LLC. And now, for Aaron's question, when you have that umbrella LLC, then you do have choice, right? If that is an umbrella LLC over several different LLCs in different states, you have a choice of where you want to put that. So then it's not as important where you put it. But yes, those LLCs that specifically are there just as property holding LLCs, almost all the time, I'm going to suggest that you put those in the state where that property is located.
Thank you very much. That's all my questions.
Aaron, I see your lips moving, but I can't hear you.
I'm sorry, I have a question. I'm sorry about that.
Yes, sir.
What is the minimum? Because I know people who have residential properties, they say, well, I can put all my LLCs into all my homes to one LLC because that represents the state. Why should you have an LLC for each property you own?
So yeah, and that kind of goes back to that you have to weigh, right? Is the extra expense worth it? But basically, it goes back to that lawsuit principle, right? That LLC is a shield. So think of it as a safe. Anything that you put in that safe, if a safe cracker comes in and gets that, they get everything in it, right? They can clean that safe out. If there's a bunch of safes and I only have time to go get one, or my blowtorch runs out after I get one, then I can't touch those other safes. So that's the concept here, is that if I put that safe as an LLC and I jam that full, I got 15 properties in there, and that safe cracker comes in, which in this case is the bad guy lawyer who wants to sue me and take everything I've got. It's all right there in that one safe. So if he cracks that safe, he wins that lawsuit, all of that becomes vulnerable to it. Whereas if I put it in separate LLCs, only that one is vulnerable. So only that one property is vulnerable to that lawsuit. So I don't lose everything. The most I've got on the line is that one property.
Makes sense to me. So let's open up for questions for Mark. Anybody have a question? Please raise your hand. Go ahead, Doug.
All right. Hey, guys. So, fascinating topic for me, and something that I'm actually going through right now, at least trying to structure myself properly. I'm a fairly new investor. I don't have a rental portfolio just yet, but I am actively looking for properties. And so the way that my coaches are having me to approach protecting myself is to purchase my rental property, but to then either directly, if the title company will allow me to, purchase that property into a land trust, and then the land trust have my LLC as its living beneficiary and my revocable living trust as its death beneficiary. That way, everything is, as you would say, every property has its own land trust. That's the only property that is exposed to the lawsuit, if someone even wants to go as far as trying to figure out who actually owns this property, to get rid of the frivolous lawsuits. But I'm curious as to see what you would think about that strategy, because it sounded like you said you have to be careful. Some title companies won't allow you to do a quick claim or whatever to get the property into the land trust. Did I hear that right, or did I misunderstand?
So you're on the right track. And first of all, Doug, congratulations. I just want to encourage you, getting started is the hardest part, but you're right there, man. So good job. Go for it and go forth.
Appreciate it.
Yeah. So there's a difference between an LLC and a trust. So under the law, there is a law that says we can transfer residential property. So commercial property is not covered by this, but residential property, so 5 units or less, into a living trust, which a land trust is a type of living trust, without triggering those types of things, a property tax reassessment, a mortgage company triggering their due on sale clause. So we have protections there. So you're fine there transferring it into a land trust. I love land trust in California. I don't know where you're located, but in California, they have really managed the law so as to make it almost impossible to have an effective land trust. But for those of you who aren't familiar with what a land trust is and why I really like them, is it is a way to put your property in trust, but you shield the identity of who owns that trust. And so that's another great sort of asset protection tool. Somebody, again, this is what I used to do in a lawsuit, right? You go, when you first have somebody who comes in, you want to go after somebody. What's the first thing the lawyer's going to do? They look at the merits of the case a little bit, but really I want to know if that defendant has any assets that's worth going after and getting, right? So they're going to look at that too. And if they can't find any assets, they're a lot less likely to spend the time and effort and money to sue you. So that's a really nice aspect of a land trust, is it shields those assets that are held in that trust so that they can't find out that you actually own that. And then, yes, the way they're talking about setting that up is correct. So the only issue you might have is, and no, you won't have it because you're not buying that as an LLC. Although I might ask them, because maybe you misunderstood them. So generally, again, I would probably set that up. And I don't do a lot of land trust because, like I said, California, they don't. So wherever you're at, they may know more about this than I do. But generally, I would want the LLC to own that property, because that's what gives you that legal asset protection shield, is when the LLC owns it. The trust in and of itself, although it can shield your identity, it does not shield that asset. And so that would be the only way that I might say, maybe double check with them and see, maybe that's what they're talking about. Or maybe they need to look at that as another option, or maybe they have a good reason for not doing that. It's always tough if somebody else is given legal advice, I don't like to step in, because they usually know a lot more about the facts and everything that's going on than I do. So while at first blush, it may seem to me like I would take a different strategy, if I got into it as much as they have and know all the facts, I very well may agree with what they're doing. So not to say that they're wrong, but that may be one other way to look at it, is to have the LLC actually be the one that owns the property, is on title for that property. But of course, to do that, you either have to buy it as the LLC. So the LLC has to be able to get financing for that property, which is sometimes tough if it's a new LLC and does not have a track record, or you have to buy it yourself and then transfer it over to the LLC. And again, you have to be careful about doing that. You have to get their permission to do that as well.
Right. Yeah, that's exactly the situation that I'm in. Since my LLCs are in their infancy, they would have me to either purchase it in the name of the land trust, but 9 times out of 10, they said, you'll probably have to purchase it as yourself. and then do a quick claim into the land trust, because they're going to want you liable for that note.
Right. And the other thing I'll tell you, and again, I'm only licensed in California. So if you're somewhere else, a quick claim deed may not have the same legal effect that it does here. I always do grant deeds rather than quick claim deeds, and here's why. When you do a quick claim deed, that it's back to what Peggy was talking about title insurance. When you do a quick claim deed, that severs that title insurance. So when we go to buy a property, that title company is looking back through the chain of title to make sure that we're getting good title. Once they see that quick claim deed in it, that's where they stop, because a quick claim deed does not have those guarantees in it. So that can create sometimes an issue, not usually for you, but when you go to sell it, that can sometimes crop up, and then the new buyer is like, wait a minute, I don't know that I have good title here, because we can only go back so far. So I always use a grant deed, because that does come with more assurances and does not sever that chain of title, so that they can continue on past that and look. So that may be, again, in California, I think that's a good strategy, may or may not hold true in other states.
Gotcha. Okay. Hey, that's great advice. So are you saying that it's still a transfer of title, but a different way of doing it? Instead of doing a quick claim, do the grant deed out of my name and into the name of the land trust?
Yeah, and you probably don't need to do that. Usually when you go through escrow, they'll ask you how you want to take title, and it's again always up to the mortgage company. Most of the time they'll let you take title in the name of the trust, because they can still hold you personally liable for that. But if they won't, that's fine. You can always go do that, do a grant deed, and as soon as you close escrow, you go do your own grant deed, throw it into the trust, record that, and you're good. And you don't have anything to worry about. The where it comes in, where you have to get their permission, is if you're then going to transfer it through deed into an LLC. That's where they can come back and get you.
Gotcha. Okay, perfect. Thanks a lot. I appreciate it.
My pleasure. Good luck to you. I'm excited for you.
Thanks. I appreciate it.
Next question. Anybody got another question for Mark? This is great information right here.
So I'll just shoot off of Doug, because I was where he is not too long ago. My wife and I bought our first investment property in 2012. So just 10 years ago, I started investing. And boy, it's an addiction, isn't it? For those of you who've been doing this a while. And it has completely changed the trajectory for my family financially, for my wife and I's retirement, for my kids' future. And that, going back to what Aaron's talking about, that is why it's so important to make sure that you protect that. You work hard to build this stuff up, and there's risk owning this stuff and managing this stuff, no question about it. So we need to do whatever we can to mitigate that risk for these valuable assets that we've got, so we can hang on to that value that we're building. But I'm so excited for somebody like Doug and anybody else who's going on this journey. It's been a great journey for me. It really can change your life. Yeah, man, I love it, and I love talking about it. So I'm happy to be here and talking with you guys. I see some other hands, so I'll shut up.
Thank you, man. Absolutely. Nika, the floor is yours.
Hi. Yes, I might have missed
Hey,
this.
Nika.
Hi. I might have missed this because I was trying to get in the car and I'm flying out to come back home. But can you explain a little bit of the difference between a land trust and then when you're saying that you just put it in the living trust?
Yeah. So a living trust is generally going to hold all kinds of different assets. So when we set up a living trust, we're usually setting up one living trust for a person or for a couple. In California, we mostly do joint trusts if it's a married couple. And then you're putting in not only real estate, but you're putting in bank accounts. You're putting in basically anything that you have, anything that's an asset that you can put in there. And so that's going to hold a lot of different things. That does not, you're going to be on title as the trustee of that trust. And so anybody that knows what they're doing, it still gives you a little bit of a shield. If somebody doesn't know what they're doing when they're looking for a deed title, they're probably going to miss that you own that property. But anybody who knows what they're doing is going to be able to tell that that's your trust that owns that property, and so that property is yours. What a land trust does is a land trust only holds that land. So it only holds that particular asset. And then what we do when we record title on that is we're able to shield who the trustee is on the deed, so that anybody, even if they know what they're doing and they're looking through those public records, which deeds are all, of course, a matter of public record, they will not be able to tell who is the actual owner of that trust. And so that property, unless they know your address, right? They know the address of that property, then it's going to be really hard for them to figure out that you own it. So again, when we're talking about lawsuits, if I go looking for property and I don't see any real estate, and all I uncover is a $10,000 bank account, I'm not going to be very excited as a lawyer about taking that case, because I know it's going to be really hard for me to get paid. And that's one of the first things that all litigators want to do, is they want to make sure that they can get paid at the end of that case. Does that make sense? That's really the goal, is to sort of take your assets out of the arena so nobody knows what they're going after, and they get less and less excited to go after you in a lawsuit.
Excellent.
Doug, you're back up next, sir.
Yes, I wanted to make room if somebody else had questions, but the other half of your presentation, as you were talking about wills and revocable living trusts, etc. I was literally just having this conversation with my parents last night, because as I'm understanding the difference between a will and a trust, I'm now trying to pass that on to them. Their situation's a whole lot easier because I'm an only child, so they're thinking, oh man, we don't really need a whole lot, because the state of Louisiana knows that you're our only descendant and everything will, go to you. But I'm now explaining to them that, okay, yeah, but you will still have to go through probate if we don't have a trust. And so some of your estate will be spent in court. And now I'm hearing about the time. I didn't even think about the time that would go about with probate, but I wanted to make sure that my advice to them was accurate. It sounds like it is, that the only way for them to avoid probate court is to have a trust. Wills will not keep you out of probate. That's correct. Is that not true?
So when I talk, I can really only talk with any authority about California. And legally, that's all I can talk about, even if I know about other states, and I know a little bit about a couple of other states, but I would never tell you what it is in Louisiana, because first of all, I'm not legally allowed to, because I'm not licensed there, and secondly, I really have no idea. I know Louisiana is one of those states that does things very different than almost every other state, right? So that's about all I know. Yeah, exactly. So, just because, so when I'm talking, please understand, I'm really talking about California, and that's the way it works here. I recommend that you go talk to somebody. Not all attorneys will give complimentary consultations, but enough will that are good that you can find somebody that at least can give you some of that basic information, look at what your parents have, and tell you what they would be facing. And that's really what I do in my consultations, is I say, okay, here's what you got. Here's what your family situation is. Let's look at what your plan is. So most of the time they come in, they don't have their own plan. It's probate. So I explain to them exactly what that is. And then I say, okay, what of that don't you want? And they say, I don't want that. I don't want that. I don't want that. Okay, so let's put together a plan to address that, and that. And that's all part of that consultation. So I would recommend you go find somebody and talk to them about your parents' situation, or better yet, go with them with your parents so that they get it right from somebody who is licensed in Louisiana, who knows what they're talking about, and can really give them the exact straight answers to all of those questions. Then, armed with that knowledge, they're now empowered to really start participating. That's important. Don't just go ask somebody to create a plan for you. But I'm always a big proponent of you participating in that plan. You guys know your family and your values and your situation better than a lawyer ever will. So don't just accept whatever the lawyer writes up for you. Be a participant in that, but you'll be empowered if you have a good lawyer who educates you to be able to participate in that. So start with that. Go find a lawyer who's willing to spend some time educating you so that you can be empowered to create a good plan for yourself.
Awesome. I love it. Okay. And then one last question, I think for me, you said something that was intriguing because I asked 1,000,001 questions while I was creating my trust, but I didn't consider, for example, one of my children getting a divorce and then the assets that I left to them being up for grabs between my child and their ex-husband or ex-wife. To my knowledge, the way that I have everything outlined is that I've got 3 kids. I'm giving a third to each one. And if one of them is deceased before I pass away or those assets get transferred, then it would go either to the other 2 children or to that child's, my grandchildren, the grandchild of that, child of mine.
Okay.
But I don't have anything in there that explicitly says in case of a divorce or etc. How would I necessarily protect them or protect my assets from their ex-spouse? Is there something that I should put in there?
Yes, sir. And that's a great question. And that is where you start getting past sort of that first layer of what trust can do and start really unlocking the magic and the power of trust. When you drill down and start putting these other extra tweaks in that can do those kinds of things. So how old are your kids?
20, 22, and 24. And only my 24-year-old is married right now.
Okay. So do you know how the trust is giving it to them? Is it giving to them outright? Is it giving to them in trust? Do you have any idea how that's set up?
Yeah. So everything is going outright.
Okay. And right on your death. So your 20-year-old will inherit a third of what you have immediately upon your death?
Yeah. Technically, It's written that after their 21st birthday, but he turns 24, 21 in like a week and a half. So unless somebody bumps me off pretty quickly, he should get it.
Right. Okay. So that works. But the problem with that is, maybe it's not going to happen soon, but maybe 10, 15, 20 years down the line, one of your kids gets a divorce. Then any of that stuff, and I'll just take a quick minute and kind of backtrack because, again, I'll speak on California law. Anything that you inherit is considered your separate property, and that's not subject to a divorce. Only community property is. The problem with that is it is almost impossible to keep separate property separate. There's a concept in the law called transmutation, where your separate property that you inherit from a parent transmutes to community property during the time that you're married. Because it is, like I said, it's just almost impossible to keep it separate. So then that becomes subject to the divorce, right? So the problem with the way you've got it set up would be, let's say one of your creditors or one of your kids has a creditor. And it can be something, as simple as they're mismanaging their money and they didn't pay off a credit card. In which case I want some controls. If my kid is not managing money well, I don't want to give them, $1 million and have them squander that, right? So I want some protections in there that says if they can't manage their money, they don't get this yet. They got to figure that out first. The other thing is it could be something big, like they could have gotten in a car accident and somebody died and the judge found them at fault, right? And then they've got a wrongful death suit on their hands. As soon as they get that inheritance, it doesn't even touch their account. The court seizes it and gives it to that person. So they never get any of it, that somebody else gets all of it, right? So that's even worse than the divorce scenario where somebody else gets half of it. So there are those scenarios that can come up that could take it away. So what we always look at, and it's your choice what you want to do. But if you're interested in the concept of protecting it, we don't give it to our kids outright. What we do is we have our trust set up what's called a lifetime asset protection trust. And there's a lot of different names that lawyers use for it. I call it a legacy trust, but that's basically sort of, you say lifetime asset protection trust, LAPT, and most lawyers will know what you're talking about, what you're looking for. And what happens then is we write the language in your trust that when you die, your trust is going to spin off a trust for each of your kids. So it's going to spin off 3 of these lifetime asset protection trusts. And instead of your assets going to your children, it's going to go into this trust for each of your children. Now, your children can be the trustees of that trust, so they can control those assets. They are also the beneficiaries of those trusts, so those assets are for them. But as long as those assets are held in that trust and left in that trust, they have a lawsuit, waiting for them, they have a creditor, they get divorced, that has that shield around those assets and nobody can come take that. And it lasts for their entire lifetime. And so again, if they're good stewards of those assets you give them and they grow their assets, they can spin that off to their kids in the same way. And so it's a really powerful tool for growing those assets from generation to generation. But that is something to, again, find somebody in Louisiana or go back to the lawyer that drafted that and say, hey, why didn't you tell me about this? Talk to me about a lifetime asset protection trust.
Gotcha. Yes. Thank you very much. This is invaluable. I appreciate it.
My pleasure. My pleasure.
Well, look, guys, we are at the top of the hour. I'm going to hit the unrecord button, and you can stay on and ask Mr. Mark more questions. Stay on. So, unless you have something else, Peggy, you want to include?
No, I just want to thank him very much for being here. What great information you gave, Mark. Thank you so much.
You're welcome. And I love this show. So I try not to miss it. And I hope I can meet the standard you guys set. There's such great information you guys put out week after week. So I really appreciate you including me in this. And I appreciate just what you do every week.
Thank you.
Thank you,
Such a
Mark, so
wonderful
much, sir.
program.